Hello. Today we're talking about Chapter 18 in the book Get Your Michigan Driver's License Back, which I co-authored with attorney Matthew Zick. This chapter deals with the substance use evaluator as expert witness. Recently, an attorney that we do some work for asked us to comment on a compilation of suggestions from another attorney for their clients in driver's license appeal cases. I looked it over and many of the suggestions were good, however, not all of them. Some of them would be counter to the advice that I would give my clients who are not represented by counsel, or that other attorneys that I do work for might advise their clients. For beginning, for starters, the attorney suggested that the appellant obtain an evaluation at a counseling center that is affiliated with a hospital or a doctor's office in order to obtain the drug screen at a cheaper price. I would say that this is maybe being penny wise and pound foolish. It's going to cost you more for an attorney than it will for the evaluation. However, the evaluation is the evidence that you must have in order to be successful at the hearing. If your evidence is bad, you will not get your license back no matter how good your attorney is. So it's questionable that an attorney would send you out on your own without giving you a recommendation of this person or that person that they work with and have trust in. The attorneys that I work with refer to me, and there are other attorneys who refer to maybe another evaluator. They may or may not be good. I don't know all of them, but I think it's a good practice to refer to somebody that you know. Also, if you are trying to save $1, saving it on the substance use evaluation is not a good idea. You're actually better off to go with a good evaluation and without an attorney than with a bad evaluation and a great attorney. Because if there is something that is said in the evaluation that is contrary to your interests or negative about you, and an evaluator can do this without having any intention of sabotaging your case, but just by being inexperienced, they might say something inadvertently that they think is going to be helpful, but it turns out to be damaging. And there's nothing an attorney can do to overcome that kind of a mistake. Okay, it's important to keep in mind that the practice parameters are very loose around who can do a substance use evaluation. Anybody with a master's degree in a mental health discipline or a certificate as a substance abuse counselor can legally do one of these substance use evaluations. And that means a lot of people that don't specialize in substance abuse or who may be familiar with the treatment process but aren't particularly familiar with the court process or the appeal process through the Secretary of State administrative hearing section. And if you're not familiar with that, it's unlikely that you're going to be able to do an evaluation that's going to be helpful to the client and put him in the best possible light. I like to tell my clients that I won't lie for you, but I will try to put the truth in the best possible light so that you have a decent chance of being successful. Now, what kinds of things can appear in evaluation that will probably sabotage your case? Well, here is an example of some things that the evaluator can say. For example, an evaluation in which not all of the offenses are included in the evaluation. Immediately, you are going to be denied on that basis. If you've left one or two, or in one case I had 3 convictions for drinking and driving or substance-related offenses that were left off the record. And if you have that, the hearing officer is going to feel that the evaluation was done without proper information. So how can an evaluator accurately assess you if he doesn't have all the information that is necessary? Sometimes clients want to argue with me about whether or not their conviction for possession of marijuana is relevant to their driver's license appeal. Well, it's not what you and I think. It is a matter of law that these things appear on your driving record, and it is a matter of fact that hearing officers will take into consideration any other substances that you use or abuse, either legal or illegal. And these things are relevant to whether or not you're a safe driver, which is why they consider them. So it's not about what you think is fair, and it makes no sense at all to withhold information if they already have it, because these things, as I said, are on your driving record. So if you lie to them and they know that you're lying to them, you're going to be denied. It's really harmful too when you claim to have sobriety for a longer period of time than is possible given the date of your last offense. For example, if your last drinking and driving offense was November 1st, 2005, and that you claim that you've been sober since November 1st of 2003, then the hearing officer knows that you're claiming 2 years of sobriety that you cannot possibly have. Now, you may feel it's so long ago it doesn't remember, and how can I, it doesn't matter, and how can I remember that far back? And that's understandable, why you would think that way. However, this is a court of law, and the facts matter. The hearing officer is, for all practical purposes, the judge, and he's trained in the law, and 2 years make a lot of difference to him. And frankly, 2 years make a lot of difference to anybody who's assessing you in terms of whether or not you are credible. If the evaluator fails to put a diagnosis in, or if he diagnoses you in a way that, with a diagnosis that is not really commensurate with the kind of evidence that you present, then the hearing officer is not going to view that as being a credible diagnosis. For example, I had one client who had 5 offenses for substance-related matters and was given a substance abuse rather than a substance dependence diagnosis. If you have a substance abuse diagnosis and the evidence warrants a substance dependence diagnosis, the hearing officer is not going to give a lot of credibility to that evaluator. So it's important that the diagnosis matches up. Likewise, you have to have a prognosis that is favorable. If you have a prognosis of fair or guarded, for example, it's unlikely that the hearing officer is going to have enough confidence in you to put you back on the road. So a good or an excellent prognosis will be necessary. And if I can't give you that prognosis, I will tell you that maybe you need to wait a little bit longer, have a little bit more sobriety, maybe go to a little more therapy or AA meetings. If, in my opinion, you're not ready, I will let you know that rather than giving you something that is not going to be helpful to you. Different factual data other than what you have reported on a previous evaluation, that's going to be a problem also. And what's important about that is if you are correcting misinformation from a prior evaluation, you can state that. There was misinformation, either I wasn't truthful or the evaluator got it wrong or whatever. You can say that there was a mistake on the last eval and this is the correction. However, if your dates of sobriety are different and a whole bunch of stuff is different than was previously reported, then the hearing officer is going to come to the conclusion that either you weren't truthful on the past evaluation or you're not being truthful on this one. And consistency is extremely important. This is why they basically ask you the same information 4 times each time you go for the hearing. There is the evaluation that I do, there's the request for hearing form that you fill out, there's the letters that you get of support, and there's what you say at the hearing itself. And if you don't say the same things every time, then you're not going to be viewed as being credible because you're not consistent. Also, if the evaluator states in writing that he thinks you need more therapy or more AA than you've had in the past, or that you need to do something that you have not done or are not doing, then it's probable that the hearing officer is going to view you as not a good candidate for a license because your sobriety is not secure enough with the things that you've done already, and you need to do more, and it's likely that they will ask you to come back. So these are many ways in which an inexperienced evaluator can sink the candidacy of even a person who's qualified for a license by saying something that is not true, or just by being sloppy about the information that you provide in the evaluation. Also, you can be in recovery from your addiction to alcohol, but if you're abusing other substances, for example, I had a client who came to me with a diagnosis from a prior evaluator that he was addicted to legally prescribed opiates. Well, whether they're legally prescribed or not, if you're addicted to any substance that's going to impair your driving ability, you're certain to be denied at a hearing. It's better to tell the client you need a little bit more time, and I recommend that you get a little bit more time under your belt and maybe a few more meetings or some more therapy before you go, than not to say anything about it and just to give you something damaging in the evaluation and where you're beat before you start. Now, the attorney who authorized the above-mentioned suggestions also recommended that clients obtain the requested letters and other verifying data before they obtain the substance use evaluation. I always tell my clients, please don't do that until you see me, because oftentimes they will bring in letters that are not adequate. And the most common mistake that people make is they have letters that don't state when they had their last drink or drug. Now, why do they do this? Because actually in the form itself that the state of Michigan provides you, it does not ask for your last drink date or your last drug date. It asks the last time the person had knowledge of you having a drink or a drug. This is what they ask for in the letters. So most people would think under those circumstances, well, I've only known this person 2 years, I've been sober for 5 years, so all they can really vouch for is 2 years. Well, that's logical, but that's not what they're looking for. They want to know that you've told this person, I've been sober since November 1st of 2005, or whatever your last drink or use date was. And this person is essentially vouching that as far as they know, you have been sober as long as you say you have. If you have people giving you glowing recommendations, but who don't know when you last drank, these letters are suspect. They're not considered to be very helpful. So this is a case where actually what the state is asking for is not what they are looking for. The hearing officers want to know when you had your last drink or your last drug. Also, the state's recommendation is that you get 3 letters. That's the minimum that they require of support from people that you know, verifying your sobriety dates. However, it is a good idea to get more than is required for a couple of reasons. One is that one of your letters may not be adequate. Somebody may leave something off of that one. They may leave off the date or the signature or something important such as your last drink date. Your letters must be signed, dated, notarized, have your last drink date on them, and the contact information for the person. At a minimum, they must have the information. If they lack any of that, the letter will be thrown out. So it's a good idea to get 5 or 6 letters so that if any of them are set aside, you will have 4 or 5 good letters from people that know you that can vouch for your length of sobriety. Letters that require rewriting may cost you time. However, a drug screen that is done improperly will cost you money. And there's no reason for you to go out and get a drug screen from somebody who does not provide you integrity variables. Your drug screen must have 10 drugs. It must be a 10-panel drug screen with at least 2 integrity variables. And even after I tell people this, if they have it done someplace else, oftentimes they bring me a drug screen that does not have integrity variables. The person on the front desk is probably not going to know what you're talking about when you ask for integrity variables. So it's better to do it here, because I will do it right. I will send it out to a lab. It will be done according to forensic protocol, and it will have 3 integrity variables. But if you're going to have it done someplace else, we should talk about it first. That's why I prefer that you come in, we do the eval first, and then everything else builds off the evaluation. And then, you know, the attorney said that AA is a must. Well, you know, if you haven't been going to AA all along, then it's not probably a good idea just to go for a couple of months before your hearing and try to convince them that you're an AA member. They're not going to be fooled by it, and they're going to ask you questions about AA, which if you're not an active member, you're not going to be able to answer. It's better to tell them a realistic story about what you are doing and how your life is improving, the relationships that you have, your job situation, your money situation, every aspect of your life, your health, exercise, all of that should be improving if you are in recovery from substance dependence or substance abuse. And you can make a convincing story without going to or telling them that you're going to AA when you're not. I always tell people it's better to make a good case for what you are doing rather than a bad case for what you're not doing. And sometimes the hearing officer will turn you down because they just don't feel that you've done enough, that you haven't been to enough AA or enough substance abuse therapy. If the hearing officer says that you need to do this before you come back, then you need to do it. They are not going to like it if you come back in a year and you've not done the things that they asked you to do and you're requesting a license. So these are ways in which the substance use evaluator is your expert witness. The evaluation is your expert evidence at the hearing. If it's done well and you are prepared, you should do well. If it's done poorly, there's very little that anybody can do to save you. Thank you.
All right. That one was